Void wills under Indian Succession Act. So under this, the first section is the 59. It is about the persons capable of making will. Section 59 is about the persons incapable of making the will. First is the unsound mind. A person is incapable of making a valid will unless he is of a sound mind, memory, and understanding. Means if he is of an unsound mind, then he is incapable of making a will. Second is the minor. The minor is not competent to make a will. Deaf, dumb, and blind person. Those persons are incapable of making a will. Next is the lunatic. During the lucid interval, no person is capable of making a will who is not of a sound mind, memory, and understanding. Drunkenness, the fact that the person must be in a normal state of a mind at the time of signing the will. And last is the old age, illness, and infirmity. These are all the constituents of the section 59. It states that the persons who are incapable of making a will. Next is section 61. It is about the will obtained by the fraud, coercion, or immorality. Then such a will is also considered as a void. Immorality means any such act, gesture, or conduct which takes away from the testator the free agency. It must be such immorality means pressuring or urging. Means here the force, fraud, or coercion is put on the testator to make a will. And if such a will is made without a free consent, then such wills are considered as a void. Immorality and undue influence by which a person is induced to act otherwise than by their own free will. Means without their free will or a free consent, such wills are made, then such wills can be considered as a void as they are made under undue influence. Next is the will made under a mistake. It is also considered as a void which the wills are made under the mistake. There is no special or a separate provision for this. Example of the void will. A threatens to shoot B or to burn his house or to cause him to be arrested on a criminal charge unless he makes a bequest in favor of a C. Means here the A has put an undue influence or he is doing the coercion, force on the B to make a bequest in favor of a C. Otherwise he will shoot or he will burn the house or he will cause him to be arrested. So B in the consequence makes a bequest in the favor of a C. So such a bequest is void, the making of it having been caused by the coercion. As we can see here that the B has not made this will by his free consent or by his will. So such a will is considered as a void. So when the question is asked that short note or explain void wills under Indian Succession Act, that time we have to write this section 59. In it, it states about the persons incapable of making a will. Next is section 61. It is about the will which is obtained by the fraud, coercion, or immorality. Then such will is also considered as a void. And last is the will which is made under a mistake.